Okay, so going into it, the actions of medical malpractice, it gives me a time frame, a basis for the claims that should be brought about and how long they should be brought about once noticed or found out about. As you can see, I highlighted this paragraph and these subsections. It says for any accruing on or after July 1st, 1998, and except as otherwise provided in this section, no claim in tort may be brought against a licensed physician, osteopath, dentist, hospital, institution for the aged or infirm, nurse, pharmacist, podiatrist, optometrist, or a chiropractor for injuries or wrongful death arising out of the course of medical, surgical, or other professional services, unless it is filed within 2 years from the state or from the date of the alleged act, omission, neglect, shall or with reasonable diligence might have been first known or discovered, and except as described in the paragraphs below. So, basically, the important part is here. Unless it is filed within 2 years from the date the alleged act, so on and so forth, might have been first known or discovered. Known or discovered. So, in terms of this illness that Sandra found out about, regardless that it was 6 years after the actual surgery, she didn't know about it until 6 years after. So as long as it's within the 2 years after the 6 years, I know it's kind of a confusing way, but after she finds out about it, she has 2 years to bring forth the claim, and that's upon reasonable diligence. So that is the statute of limitations aspect of it. For this binding authority, let me take you to the Mississippi Discovery Rule. But before then, it was a link over here that I wanted to look into a little bit further. All right, so I'm reading this part, the notes of the decision. It says, in most cases, Mississippi limitation statute for negligence actions commences to run on the date of the wrongful act, and the date injury was or should have been discovered is the date the cause of action accrues, only in exceptional cases such as where plaintiff establishes fraudulent concealment. Limitations of actions. So this is interesting. I didn't come across this in my previous research, but for the sake of this, I don't find it necessary to stop. I'm going to go ahead and take you on this little journey, and then I'm still giving you an answer and let you know. Does not begin to run until the... All right, here he goes. Hawkins versus Jones. The statute of limitations on a medical malpractice claim does not begin to run until the plaintiff has knowledge of the injury, has knowledge of the cause of the injury, and knows the relationship between the practitioner and the injury. So this is the discovery rule that I was looking for. I had a whole nother route to get to this answer, but this is great. So I'm gonna go ahead and highlight this so you all can see this binding source. Yeah. Okay. It's not working. So let's see about Hawkins versus Jones. A patient brought medical malpractice claim against doctor, failure to diagnose as tendon dysfunction and stress fracture in patient's left ankle. Okay, so yeah, this is kind of similar, but it's not a result of contamination and negligence. It may be negligence because the doctor didn't diagnose it. So Issues concerning the statute of limitations are questions of the law, which are reviewed de novo. And that just means that the decided issues are without reference to any other previous decision or legal conclusion by a previous court. Okay, so yeah, this still stands. Limitations period on a patient's medical malpractice claim against a doctor began to run on the date that the patient learned she had a tendon dysfunction and stress fracture. I don't know why I can't talk today, but in her ankle that had remained previously undiagnosed despite prior medical treatment she had received from the doctor, and that she would require additional treatment where on that date patient knew or reasonably should have known the alleged act, omission, or neglect forming the basis of the suit and the occurrence of at least some associated injury. So this is interesting. So this is saying that the statute of limitations on a medical malpractice claim begins when the plaintiff becomes aware of it. And it says right here, even if the plaintiff does not know with absolute certainty that the conduct was legally negligent. So this is good. So this actually this lets me know that the statute of limitations is good in this case. I'm open to learn otherwise. If anyone has a different opinion or if they interpret this a different way, then I'm open to hearing it. But from this research that I just conducted, I think it's pretty clear and cut. I'm going to still show you the third one that I originally set out to show you, but that answered that question. Okay, so this is what I was going to show you all. This actions without prescribed period limitations, actions involving latent injury or disease. Latent is a key word, and if you don't know what that means, it is Wi-Fi a little slow today, but it's existing but not developed or manifest. It's hidden or concealed. So the HIV would be latent. So, excuse me, that's why I chose this one. Wow, this research definitely took a different route, but I am appreciative of the different link that I found. This is really good. This is definitely fulfilling. Like, it's good when you research something. Oh, never mind. I'm getting off track. In actions for which no other period of limitation is prescribed and which involve latent injury or disease, the cause of an action does not accrue until the plaintiff has discovered or by reasonable diligence should have discovered the injury. All right. So I have presented about 3 binding authorities, maybe a little bit more depending on if one is what I think it is. But my research shows me, it tells me what I think I need to know. From there, I'm ready to go ahead and think about this. So taking all of that in, I presented to you a case, University of Mississippi Medical Center versus Pounders. I spoke about the Mississippi statute of limitations, the discovery rule, a different case, Hawkins, that I did not write down for some reason. But I will definitely drop these hyperlinks in my posting. But to sum it up, my final answer is yes, Sandra will succeed based on not just the discovery rule, but in my opinion, she will succeed based on both